Welcome to Trademark News. I'm Hayley Tarr. There are now 154 pending and registered trademarks on the Australian Trademarks Database that cover metaverse goods and services. The earliest of these dates back to the 9th of November 2021. So this is a very recent and emerging descriptor to see in trademark applications in Australia. For example, Kia Corporation has a registration for design and development of application software for Metaverse in Class 42. Hyundai Corporation has a pending application for software for Metaverse. Jaguar Land Rover has applied for advertising and marketing services provided by means of the Metaverse. Samsung Electronics has a pending application for downloadable image files featuring avatars for Metaverse. Mars Australia has a registered trademark for Maltesers for entertainment services, namely providing products for use in metaverse platforms and metaverse environments. That one does seem like a bit of a tease to me because it would seem quite a shame not to be able to actually eat a Malteser, but actually just get a digital version in the metaverse. But anyway, American Express has a registration for banking services in the metaverse and other virtual worlds. And MasterCard International have filed for downloadable computer e-commerce software to allow users to perform electronic business transactions in the metaverse and other virtual worlds. And finally, Rolex have filed for multimedia broadcasting in the field of the metaverse via the internet. So that's just a snapshot. It's not all of those 154 marks, but they're big players. You know, you can see that the big car companies are moving into the space, the big banks are moving into the space. So we should all be paying attention. Just to give a bit of general context, the metaverse is a set of different virtual worlds. So some of the bigger ones are Decentraland and Sandbox that are based on the blockchain. So for example, Decentraland's based on Ethereum. I've been playing around in a few of the various metaverses lately, and they feel like video games, but for adults. Like think Minecraft, except now this is our new way of conducting business, where users will be walking around with their avatars to a shop, for example, and then buying a product from that shop as if it was a real shop. And they may even do so with a virtual reality headset. So for all intents and purposes, it feels like they're walking around a department store picking out what they want to buy, but they don't have to leave their lounge room to do so. So these shops will benefit from being in desirable locations with strong online foot traffic in the same way that bricks and mortar shops benefit from being in a high-end shopping centre, for example. And businesses are starting a land grab for these locations in the metaverse. But equally, as we've discussed above from these 154 Australian marks, businesses are starting a brand grab to protect their mark in the new frontier of digital goods and virtual services via the metaverse. But there are some unknowns. As we go into this grab, what will it actually mean for trademark owners? Because the metaverse is decentralized. So does it make sense to have a system of trademark registration by jurisdiction? If I register Tar Law as a trademark in Australia, but then I use it in Decentraland, there may be other law firms from other jurisdictions that equally have valid registrations for Tar Law as their trademark in the US or China. So which of us has the right to use Tar Law as the trademark in Decentraland? Do we all? We all have a trademark registration. We've all raced out and got one for provision of digital goods and virtual services via the metaverse. But if we all provide those same services via the metaverse, what's going to stop confusion happening between the different service providers with the exact same marks in the metaverse? Now, currently, there are websites which are accessible all over the internet. And, you know, there may be traders in one country that have a website and a trader in another country that has a website. And so you might think, well, this situation already exists. But those websites are often limited in jurisdiction by, say, for example, the .au top-level domain. Also, the acceptance of payment in a particular currency. Like if I only accept payment in Australian currency, then my website is directed towards Australia. So even though it's accessible by people around the world, it's deemed to be a website for trade in a particular jurisdiction of Australia. And they may also restrict delivery of goods purchased via that website to particular addresses. So I might only deliver goods to addresses within Australia, and therefore, again, my website, although accessible worldwide, is limited in jurisdiction to trading within Australia. So therefore, that use of that trademark would be limited to Australia. But none of these things will apply in the metaverse. The currency is cryptocurrency. It may be specific to that particular metaverse, or it may be, standard crypto blockchain. Bitcoin. And then the delivery of digital goods occurs within the metaverse itself. So there's no tangible address to say, well, it's restricted to a particular jurisdiction. So there's no geographical restriction of use within the metaverse. So therefore, geographically restricted trademark registrations don't actually help avoid confusion within the metaverse. Can we stop confusion by the current trademark registration process, or does this mean that we need a system of registering marks for the metaverse, such as a universal metaverse registration system across all countries? So I might have jurisdiction-specific trademarks for the real world, but I might have a metaverse registration for all of the metaverses. Or do we have a registration system specific to each metaverse? So Sandbox, you might apply for registration in that particular metaverse. And then Decentraland, you might apply for registration in that particular metaverse in the same way that I would apply for registration in Australia, then I might apply for registration in New Zealand. Or do we need a jurisdiction-specific metaverse? So, for example, the Australian government develops an Australian metaverse, and the New Zealand government has a New Zealand metaverse. And when law firms set up shop, we set it up in the Australian metaverse. Therefore, there's no confusion that I might be potentially trading in a country where I'm not registered to operate as a solicitor. Once we figure out how to protect trademark rights in the metaverse, we then have the whole next question of how to police them. So Horizon Worlds, for example, is one metaverse that's implementing traditional takedown protocols, the same as many online, social media sites have takedown notice provisions. But then other metaverses have completely different systems. So Sandbox requires users to exhaust all self-help options before the platform will become involved in any dispute. So it will become incumbent on users to do their own IP policing, which can be difficult, particularly, because of anonymity in the metaverse. So there are a lot of issues that are unresolved still around trademarks and the metaverse. With so many companies registering their trademarks for digital goods and virtual services, it's clear that we can all foresee the importance of the metaverse. We just now need to figure out how trademark protection and enforcement should be implemented within the context of the metaverse. That's all for this week. That's Trademark News. I'm Hayley Tarr, and come and see me if you have any questions about protecting your trademark in the metaverse.